Duterte allies have filed a petition to block the impeachment trial of Vice President Sara Duterte. Here's the report.
Allies of the Duterte family have filed a petition before the Supreme Court to halt the impeachment trial of Vice President Sara Duterte. Among their petitioners are lawyers Israelito Torreon, legal counsel of detained Pastor Apollo Kibuloy, and Martin Delgra, former LTFRB chief under Rodrigo Duterte's administration. They have requested the Supreme Court to issue a temporary restraining order and the writ of preliminary injunction to block the Senate from moving forward with the impeachment trial. Torreon argued that the articles of impeachment filed against the Vice President are defective. He added that they failed to meet the constitutional requirements for verification and proper initiation of impeachment proceedings.
Kung tinama nila yung ginawa sa House, sang-ayon sa saligang batas, wala po kami rito, hindi kami magpa-file. Talagang nakita nyo naman siguro, ni railroad yung proceeding. There was no debate, there was no deliberation. It was just introduced and voted upon.
In response, one Rider Party List Congressman Rog Gutierrez maintained that there was nothing unconstitutional about the impeachment.
Naniniwala po kami na kompleto po yung aming articles of impeachment, including the process in which it was transmitted to the Senate. Ayon po sa ating saligang batas, yung Constitution, nandun naman po yung mode. So I'm not sure po kung anong basis na sinasabi na flawed yung impeachment po.
For now, the Supreme Court has ordered the Senate to comment on a petition for mandamus, which seeks to initiate the impeachment trial without delay. Mobile journalist Marymon Reyes, we are One News.
Meanwhile, senators are still divided if the upper chamber should now act on the impeachment complaint. Senate Minority Leader Coco Pimentel called on Senate President Chis Escudero to begin the trial, saying it is the Senate's constitutional mandate to do so. Speaking up for the first time, Senator Risa Ontiveros says she also believes the Senate should get to it. But Senator Amy Marcos, a known ally of the Vice President, believes that the impeachment trial can wait until after the elections.
Malinaw ang utos sa amin na once matransmit sa amin ang articles of impeachment tulad ng nangyari, ay agad po kaming mag-convene.
Hindi naman natin masasabi na urgent requiring the calling of a special session. Yun lang ang pakiwari kong personal. Parang hindi justified dahil hindi naman siya urgent.
Let's talk more about the petition against the impeachment of Vice President Sara Duterte.
Joining us now on the line is Atty. Israelito Torreon. Good morning. Thanks for joining us today.
Hello, good morning, and good morning to all viewers and listeners of this popular station, ma'am.
All right, Attorney, let's get right to it. First of all, yung petition na final niyo po sa Supreme Court, are you doing that on your own volition po, or are you representing officially po yung kampo ni Vice President Sara Duterte?
Well, I am doing it in my own volition together with the other lawyers from Mindanao and concerned citizens as well as concerned bloggers po like Banat Bay, Coach Oli, and Boss Dada po. We have decided to collaborate in order to file this petition and possibly obtain a TRO and thereafter injunction and thereafter an order of prohibition from the Supreme Court stopping the trial in the Senate. Yes, sir.
You mentioned in one of your interviews that the articles of impeachment in these complaints are defective. Can you expand that to us po?
Well, it is really defective because I know the basis of the House of Representatives. They're basing it on the fact that they have 1/3 vote in accordance with Article 11, Section 3, Paragraph 3 of the 1987 Constitution, and that. But our basis is that it should be struck as void, as it is constitutionally infirm and it is jurisdictionally void, and it suffers from inherent defects in the light of the fact that number one. It did not take into consideration the fact that there were 3 priorly filed complaints against for impeachment against Vice President Sara Duterte. And if you read Article 11, Section 3, Paragraph 2, no, there should have been outright actions on the part of the House of Representatives insofar as any of the first three complaints is concerned, because under Section 3, Paragraph 2, Article 11, the 1987 Constitution, once the verified complaint for impeachment is filed, the House of Representatives is mandated to include it in the order of business within 10 session days, and thereafter it should be included in the it should be referred to the proper committee within 3 days, 3 session days thereafter. And if you relate it with Rule 2, Section 3 of the House of Rules of Procedure on Impeachment, it is even imperative on the part of the Secretary General to refer it right away to the Secretary so that it will be included in the order of business within 10 session days. And the Secretary is mandated by their own rules to refer it to the Committee on Justice within 3 session days. These mandatory provisions were not followed in this case insofar as the 3 complaints is concerned. Second, even the House rules of the House of Representatives, Rule 2, Section 2, provides that even if you have 1/3 vote, their own rules provide that this should pass through the Committee on Justice, and the rules provide that the Committee on Justice would determine, in effect, whether or not it is sufficient in form and substance, and that they could not contradict this because it is provided in their own rules. And number 2, we likewise cited the fact that there is here a defective, verification process. If you read the Constitution of the matter, if there is a 1/3 vote, it begins that in case the verified complaint is supported by at least 1/3 of the House of Representatives, trial in the Senate shall forthwith proceed. But the requirement is that there must be a verified complaint. And verification implies that you have personal knowledge of the fact that you have stated in the impeachment complaint, and you have assessed the evidences thereof, and you have seen on TV that on February 5, the congressman did not even know the subject matter of the House caucus, and they had only very limited time within which to read the complaint, much more assess the evidences attached in the complaint. So therefore, if you relate it with Rule 4, Section 14 of their own House rules, they even have the wordings of the verification that should be cited in the complaint. The wordings in the verification in Rule 4, Section 14 does not appear in the complaint as actually filed in the House of Representatives. And finally, the due process clause of the 1987 Constitution was not followed. Note that Vice President Duterte was not even informed of the actual complaint that was filed in the, in the Senate. No? They might argue that there were investigations that were conducted in the past, but Vice President Duterte has already answered the same. But the actual complaint that was actually filed before the Senate, it is a fact that Vice President.
Okay. Attorney, are you still there? Can you hear us okay? Nawala ata si Attorney. Attorney?
Hello?
Yan. Can you hear us po?
Yes.
Yeah. Okay po.
Yes.
Yun nga po, no, sinabi ni Congressman Rog Gutierrez na expected naman daw po ito sa kampo ng mga supporters si VP Sara na mag-file ng ganitong petisyon sa Korte Suprema para na rin daw po talagang mas ma-interpret yung batas. Pero sa kanilang hanay, sinasabi nila, wala naman daw silang nilabag sa kanilang proseso. And in fact, prior to this impeachment complaint, yung una pa lang po yun 1 and 2, we had former Senator Laila de Lima on the show saying na, sinasabi niya po na oo, may procedure na merong idadaan dapat sa Committee of Justice, pero meron ding proseso na kailangan nga daw po yung 1/3 of votes ng Kamara, which is hindi na kailangan idaan pa sa Committee on Justice.
Well, that is their contention. I respect their opinion. But if you read Section 3, Paragraph 4 of Article 11 of the 1987 Constitution, it clearly states, in case the verified complaint, resolution, or impeachment is filed by at least 1/3 of all the members of the House, which means that before you go to the phrase, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed, you have to comply with the requirement in case the verified complaint or resolution of impeachment is filed. So what is verification? You have to look into the rules of procedure of the House of Representatives, and Rule 4, Section 14 mandates a particular procedure that should be followed. And besides, Rule 2, Section 2 of House of Representatives mandates that even if you have one vote, it should first still be referred to the Committee on Justice. Are you saying that when they wrote and they crafted the House House rules, they did not take all these into consideration and simply disregard it when there is already an impeachment complaint against a high official? Note that in Francisco versus House of Representatives, the Supreme Court was emphatic in saying that the impeachment process is a solemn process. It must follow the stringent fundamental rules and procedure, which must be stringently followed likewise, because you are impeaching an official who has been voted by 32,208,417 souls and individuals. And we have here a situation where only 215 congressmen who have rashly and in a blitzkrieg fashion filed this complaint without following their own rules. Then we really have a problem, madam. And this problem should be resolved by the Supreme Court simply because of the fact that in Corona versus Senate, the Supreme Court did not have the chance at that time to rule on the merits of the case. And this is now the most opportune time to rule on this, because this is concerning a person who has been elected into office by 32,208,417 voters, whose votes are sacrosanct, sacred, and which must be protected by the law as well as the 1987 Constitution.
Yes, Attorney, para palinawin lang for our viewers, no? So are you saying in essence, before na transmit to for signature for the 200 plus congressmen, yes, dapat po dinaan ito sa Committee on Justice to ascertain yung substance and form? Is that what you're saying, Attorney?
Sa kanilang rules kasi, nakasaad na dun sa Rule 2, Section 2, pakibasa po ninyo, dapat daw dumaan sa Committee on Justice, sabi nila. Doon sa kanilang rules. Ngayon, hindi nila sinusunod. Ano yan? Kung hindi nyo sinusunod yung sariling rules nyo, ipafile ninyo at the last 30 seconds before the House session is adjourned or before the Senate session is adjourned. Then you are rushing things. You do not want any discussion on the matter. You have railroaded the process, which should have been considered as a solemn process, which should have followed stringent procedural rules. So what does that imply? It implies that you are rushing things so that it cannot be known to the people, and there will be no compliance with the due process clause.
Yes.
And the due process clause mandates that no person shall be deprived of life, liberty, or property without due process of law. She was duly elected by the people, 32 million, and the process for her removal should have followed the stringent procedural rules mandated under the 1987 Constitution, but which have been altogether denied by the 250 Congress.
Well, Attorney, we understand
That's
that
my
part.
point.
Yeah, Attorney, we understand that part. I'd like to, as reference yung nangyari po kay President Joseph Estrada sa Congress. Do you think that this has similar instances? Yung kay pag-transmit ni Villar, Senate President, then Speaker of the House Villar?
If I'm not mistaken, I think that matter passed the Committee on Justice. But even if it did not pass, you have to relate it with the House rules of the present Congress. The fact remains that in the present Congress, they provided those rules. So they are mandated by law to follow the rules that they have set. So the fact that they did not follow it, if you base it likewise on Rule 2, Section 3 of their own House rules, the first 3 impeachment complaints should have been acted. They did not act on it. Because why? Because in Francisco versus House of Representatives, if the complaint is referred already to the Committee on Justice, the 1-year bar rule shall have operated. But in this case, hindi nila inaksyonan yun para hindi mag-operate yung 1-year bar rule. Makatarunganon ba yan? Hindi yun makatarunganon kung sa Binisaya pa. Why? Because what is good for the gander should likewise be good for the goose. And if they acted on any of the three complaints, yung fourth complaint, void na yon. Ang problema pa nito, yung second complaint, si Representative Franz Castro, siya yung nag-endorse. Pero nung pumirma siya doon sa fourth complaint, no, hindi man lang yan dinisclose na meron ng prior complaint against Vice President Sara Duterte. This is a violation on certification against non-forum shopping and violation likewise of the verification rules, no? So if we should be consistent. If we want the rule of law to prevail, then the rule of law should apply even if you hate the person, granting that you hate Vice President Sara Duterte.
Well, attorney, sinasabi kasi nila, consolidated na daw yung complaint na yun from complaint 1 and 2. Pero, attorney...
That's a new argument. That's a new argument. The end which cannot be considered simply because of the fact that it is nowhere stated in the petition that it consolidates the first three complaints. As a matter of fact, there are new matters which are stated in the fourth complaint. Like, for example, the threat to life to Vice President, threat to life to the President Marcos. If it's stated in the first three complaints, it is nowhere there. That's baloney. I'm usually respectful, but when I'm seeing a lie, then I must say it also point blank.
Well, antayin natin, attorney, yung magiging aksyon ng Supreme Court dito. Pero gusto ko lang din po malaman, attorney, hindi lang po kayo, grupo po kayo na nag-file po nitong petition na to sa Korte Suprema.
Yes, 29 kami. 29
at nakita ko nga po dito,
Opo.
isa dito si former chair ng LTFRB, si Martin Delgra, and you have Acosta, councilor sa Davao. How did you come up with this team po? Paano nyo po ba napag-usapan itong gagawin po ninyo na ito?
Honestly, when I saw the impeachment complaint filed, I saw very glaring mistakes and I could not sleep at night. So I drafted the complaint. I first drafted the complaint together with my associates. I have many lawyers in the office led by my vice dean, Atty. Rizada Nolasco, and we drafted the complaint and then we showed it to them. Okay, would you be willing to join me on this? And they have some suggestions. I revised it. So they were convinced. And 29 na. May mga political bloggers pa. May prominent lawyers pa in Butuan. May magsama sana mga taga-Cebu, Dumaguete, Manila. Pero yung coordination sa pagpirma po, napakahirap yung verification requirement. Sabi ko sa kanila, mag-intervention na lang kayo. And may mag-intervene pa niyan, ma'am. Tingnan mo,
attorney,
mag-intervene pa.
Attorney, very quick na po. Sorry po, we don't have much time. Tanong ko lang po, I understand that you answered kanina that this is on your own volition, itong pag-file sa Korte Suprema. Pero after this po ba, nagkausap kayo ni VP Sara or before filing
Wala
this?
po.
Meron po ba kayong pag-uusap
Wala
na
po.
sinabihan niyo po siya na
Wala po.
gagawin niyo po ito? Wala.
Hindi kami nagkausap ni Vice President Sara Duterte. Sana po magkausap kami, pero hindi kami nagkausap po.
Okay.
You can verify that. You can have all the CCTV work. Wala po kaming panahon magkausap po ni VP Sara po.
Well, on that note, maraming salamat po sa inyong oras and hopefully we can still invite you po para po matanong naman po tungkol kay Pastor Apollo Kibolay. But for the meantime, maraming salamat po sa inyong oras, Atty. Israelito Torreon.
Maraming salamat din.
Thank you.
Maraming salamat din po.